that arise were the proper parties before Justice Okongo in Kisumu. The parties that were litigating in Kisumu were pretenders to be the owners of the land. The Kirimas pretended that land was theirs. The people who sued pretended to be the owners of the land. And that is why the judge left with any document granted the Kirima those orders. We have now filed all these documents to the attention of the judge to review that decision. We have equally written a letter to the Director of Criminal Investigation to investigate the documents the Kirima presented before the judge, to investigate the document the Dominican guy has presented with a view of establishing which are the lawful, rightful documents of ownership. Any criminal act was done, then the DCI and the DPP will take action. We have equally written to the National Land Commission to investigate the titles of this land. How did this land move into the alleged Kirima family? So we have presented documents. For those ones who have seen the judgment that was issued in Kisumu, no document was produced. The Dominican guy has the document, the original document. So we have moved to get stay of execution of those orders because under the law, it is very clear that once discovery of materials that were not available at the time a judgment was entered or at the time the case was heard, the court is bound to review its own decision. Conquered Kenya and Kenya became a colony. Before that time, land was in the hands of Africans and Kenyans. 1904, the British lands in Nairobi acquires the land now called the Kirima land. They issue a title then called an indenture, giving it to foreigners, that land, for a lease of 99 years. My good friend Wakili Swiga has taken you through the several assignments and the amount that was supposed to be paid as lease to the government of the British colony. That time the currency was not Kenya shillings, it was the